We are back for another live. We are going to be watching the YNW Melly hearing that was going on. And if you don't know anything about YNW Melly, sorry, my audio went crazy. His real name is James Demans. Great last name for this. And he is accused of killing 2 people and then staging the scene to look like a drive-by shooting. And obviously a poor job because he has been charged with their deaths. And his attorneys are accused of also helping him in staging this. And it's causing many issues for his pending trial. So they're having a hearing to discuss whether he's going to be keeping his attorneys or not. And he's already been in jail for, I wrote it down, 2,159 days. And so if he switches attorneys at this point, he's going to be adding a significant amount of time to his jail stay, which is already massive. So we're going to go ahead and watch, and I haven't seen any of it, so I'm not sure if there's a conclusion or not, but we will watch together and see what we think. There's no audio until he's actually sitting down. Go ahead and skip just a second.
Let me just put on the record real quick, everything that I've read in preparation for the all pending motions that I gave you all day today and all day tomorrow for. I endeavored to try to read everything in the electronic file, all filings and any authority cited therein that took place since this trial was declared in Mr. Demans' previous trial, which was July 22nd, 2023. So these are all the pleadings that I read that were filed by the defense. I did read also all the orders that Judge Murphy entered, but I do realize some of these may be new, but in the abundance of caution, so I would be prepared. I nevertheless did read all of them. As we go through them, I'm sure you all will let me know if it's something that I need to resolve or it's something that's already been resolved. The defense, and I'll do these in chronological order. I read the defense motion to compel Brady material that was electronically filed August 23rd, 2023. I read the defense motion to compel discovery that was electronically filed August 31st, 2023. I read the defense motion for discovery of prosecutorial investigations and prospective jurors electronically filed September 6, 2023. Defense motion for disclosure of penalty phase evidence electronically filed September 13th, 2023. The defense's motion in limine regarding phone, social media, and business records electronically filed September 21st, 2023. Defendant Jamel Demans motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health Phenomenon, electronically filed October 4th, 2023. Defense motion to exclude testimony of defendant's alleged gang affiliation, electronically filed October 4th, 2023. Defendant Jamel Demans' response to state's motion to quash subpoenas and/or for protective orders, and for an order to compel witnesses to be deposed and to attend hearing, electronically filed October 4th, 2023. Defendant Jamel Demans' motion to compel discovery, electronically filed October 4th, 2023. Defendant Jamel Demans' motion in limine to exclude certain testimony of Detective Mark Moretti along with cell hawk, call, data, record, mapping, and Google Maps, electronically filed October 5th, 2023. Defendant Jamel Demans' motion in limine to exclude certain testimony of Detective Mark Moretti regarding Apple Health Phenomenon, electronically filed October 5th, 2023. Motion to exclude testimony of expert witness and memorandum of law, electronically filed October 6, 2023. Response to state's motion to quash a memorandum of law, electronically filed October 9, 2023. Memorandum Ray, ASA, Christine Bradley testified, electronically filed October 9, 2023. Defendant's second motion for redeposition of Detective Mark Moretti, electronically filed October 29, 2023. Defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights.
Judge, that can be struck because we filed the third one and that incorporated the second. And then we're going ruling on the third one.
Okay, well, hold on. Let me get all of them done,
All right.
and then we'll go one at a time. That's why I gave you 2 days. This one is defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. That one was filed November 1st, 2023. Defendant Jamel Demans' motion to exclude, electronically filed November 2nd, 2023. Defendant Jamel Demans' motion to strike the state of Florida supplemental discovery, electronically filed December 14th, 2023. Defendant Jamel Demans' reply to the state of Florida's response to defendant's motion to strike the state of Florida supplemental discovery list, electronically filed December 17th, 2023. Objection to business record certification and/or motion in limine, electronically filed December 18th, 2023. Defendant's third motion to compel forensic images of the cell phones belonging to Christopher Thomas and Anthony Williams, electronically filed April 15th, 2024. Defendant's request for status hearing, electronically filed April 15th, 2024. Defendant's motion to set aside stay and/or modify stay to allow discovery to proceed, electronically filed April 25th, 2024. Motion to compel discovery, electronically filed May 13th, 2024. Defendant Jamel Demans' motion in limine number 2 to exclude irrelevant and immaterial YouTube videos of 1090J, electronically filed May 14th, 2024. Defendant's motion to strike the state of Florida's motion for rehearing dated May 14th,
as he's reading through all of it.
2024.
You can
That is
see that he
electronically
clearly
filed.
knows somebody in the courtroom. He keeps smiling
And then
at
a defense
them.
motion for hearing to determine potential conflict, electronically filed
And I've said
December
before, but
22nd.
I'm just going to say it again. This is in Florida. Florida has the craziest cases. I mean,
From the state attorney's
so
office, I
many
read the following.
crazy ones.
State's motion to refer to potential and seated jurors by number instead of name, electronically filed October 6, 2023. State's motion to allow former testimony of state witness, filed October 6, 2023. State's motion to strike State Attorney Harold Pryor, Assistant State Attorney Regina Falk, and Assistant State Attorney Christopher Kilran from Defendant Demans' supplemental witness list for trial, filed on September 29, 2023. This pleading was electronically filed October 10, 2023. State's motion to strike Assistant State Attorney Christine Bradley from Defendant Demans' supplemental witness list for trial, filed on September 29, 2023. That's
I'm
electronically
going to
filed
skip
October
ahead
10.
and reading.
State's
all of
motion for
the
admissibility of
electronic
consciousness
filings.
of guilt evidence and request for ruling prior to jury meeting,
Obviously a lot.
2023. Order Ray second deposition of Detective Danny Polo, entered November 21st, 2023.
Being in possession of documents dealing with Miss Liberty. If in fact Miss Liberty has to get off the case because of the conflict that she would have, This is a year too late. We should have been informed of this a year ago. So the defense team and Miss Liberty, and therefore Mr. Demans, for a year are working on this case with the state knowing that there's the potential that Miss Liberty will be indicted or an information filed against her in the exact same case of tampering with evidence and with witnesses. And if that becomes the case, she obviously, whether there's a conflict or not, that has been waived up until that time. I think the case law is pretty clear. At that time, if she has charges against her, she has to bail out.
So Miss Liberty is a part of his legal team.
In fact, I believe, and I'm not sure because it's federal case law, but I'd like to read to the court this paragraph from the case of U.S. versus Shagan, 661 Fed Sup 1289, 2009. In contrast to McLean, where the defense counsel was under investigation for a crime unrelated to charges against the defendant, here, defense counsel would have been under investigation for crimes that threatened the integrity and fairness of the trial. Were the government to inform the court at the eve of trial or during the course of trial that the defense team was under investigation for witness tampering, under the principles of McLean and as conceded by Cronin, the defense team would be forced to withdraw its representation of Dr. Shagan. In fact, David Marcus made the motion orally as soon as he heard about the investigation. Such a development would have deprived the defendant of a defense team that had been intimately familiar with his defense, causing him severe prejudice. And that's where we're traveling down right now. Even if we stay on the case right now, if charges are brought against Miss Liberty, and they happen to fall before the end of Mr. Demans' trial, we may be forced to, under the law, to withdraw as an entire defense team. But a question still needs to be asked. Why did the state wait, not to tell us, because they never told us, we had to find it out through Apple, that there was an investigation? Because a year ago, we would have sat with Mr. Demans, and he may have said, you know what, I need a new defense team. And we would have been off the case. But for a year, basically, we've been on a case that maybe we should not have been. There are things that we need to know. We need to know who reviewed the warrant, who signed the warrant for the state as far as authorizing it. We need to know whether there was a tainting. If all this information was gathered and given to the state attorneys that are prosecuting this case right now, there are innocent, innocuous, and confidential communications that will be in the hands of the state that is improper. A tainting should have been set up that reviews the documents and makes sure only those that are specific to the search warrant are looked at by the trial team. Questions need to be asked. If in fact Miss Liberty is under investigation, then why were the subpoenas sent out and why did that investigation begin now? And what I mean by that is there's a statute of limitations. The state was under no obligation to begin that investigation until Mr. Demans' case is over. Therefore, there is no perceived conflict. There is no conflict because we don't know that they're thinking about investigating Miss Liberty. But instead, we were not put in that position to know that, and a year went by. If they had waited to the conclusion of Mr. Demans' case, as I said, then there is no conflict. So the only thing that I get from this is that there's the chance that within the next whatever year, or 10 months until the trial date, 9 months, whatever it is exactly, that Miss Liberty is in fact facing charges for him. And if that occurs, then A, she can't try the case. Not sure the rest of the defense team can try the case. and don't know, and a prejudice to Mr. Demans would be monumental, that at this late stage you have to get a whole new defense team. So we need these questions answered. It's not just as simple, is there an ongoing investigation? We need to know the extent of it. We need to know the whys of when it was instituted and why wasn't it, why didn't the state, wait for this matter to be over? We need to know whether the state, if they're going to charge Ms. Liberty with this crime of tampering, do they intend to try her at the same time as Mr. Demans, or a separate trial? Obviously, at the same time, it even raises more of a conflict. We have a question, and that scares us. Miss Liberty has not been allowed to see Mr. Demans in person for the last, before I got on the case, for at least the last year and a half. When she goes to the jail, she must pick up the phone and use one of those phones to talk to Mr. Demans on the other side of the glass partition by phone. Have they been attacked?
So that's pretty crazy. The main attorney hasn't been able to see her client for the last year and a half, which is obviously not fair to him and his rights. And they don't know if the state is bringing charges towards her. So it's assumed that they are, and they've been blocked from seeing him. But that's something that they should know, because they have to be able to represent their client. And if they can't, he deserves to be able to be represented by someone else who isn't in the investigation at all. So I agree with them. This is so late notice to be bringing this up and doing this, because trial should have already happened. So as we now approach a new trial date, they need to know immediately. And I see why now they're saying that that would push back his jail time, because he's going to have to essentially start all over with new representation if this is what happens.
Have they been listened to? We need to know what communications, what has gone on. So it's not just as simple as, is there an open investigation? Now, as far as going forward on these other motions that you say, we can't go forward as a defense team on any of these motions until we talk to Mr. Demans and have him understand what's going on. And for him, first of all, to make the decision. Yes, I want to keep this defense team. Yes, I want to keep Miss Liberty. Or no, I need a new defense team. We can't do anything until that's decided. I will say that after doing the research that I did over the weekend and came up with the case I cited to the court, I think all members of our defense team need to call up the Florida Bar and to see whether we're obligated, now that we know that she's under investigation, that we're obligated or not to withdraw from the case, regardless of Mr. Demans' position. So that's where we stand today. With all apologies to the court, though, I do not believe we can go forward with these motions. Mr. Demans has a lot of thinking to do. Hopefully the court will give us a hearing and some of these questions are answered, and then he can make a logical and an informed decision. And by that time, we can find from the bar whether we have obligations regardless of his decisions.
Rutledge says, I have to find out if there's an investigation, and the state says there is. What is your authority for all those other things that you said you want answers to? Because I didn't find any authority. I don't even know how I would do that. Well, do you have any authority? I understand you're saying, that's the judge, this is what we'd like. I read what Rutledge says. That's what I'm doing right now. But you want to know about investigations. You want to know about a judge who reviewed a warrant. How would you suggest I do that? And more importantly, do you have any authority that supports any of those requests you just made?
Well, the authority that I have, Your Honor, is the Sixth Amendment to the United States Constitution, which requires me and which allows my client to have competent counsel. And without being able to go into these things, and I also rely on the 14th Amendment due process, without being able to go into these things and have a hearing where all these things are ferreted out.
A hearing, that's what I'm asking. I don't want you to confuse some type of hearing defending this liberty. That's not really the issue. That's a yes or no question, the Shanner investigation. And the answer is yes. So the only other question that Rutledge requires is that Mr. Demans has to decide, does he want to go forward with her, or Or does he want conflict-free counsel, which I think he's certainly entitled to, and if he wants to apply that to all of his lawyers, he may do that, but that's a discussion between you and your client. I can't intervene in that. You're asking me to do fact-finding on behalf of your client so your client can make an informed decision.
Well,
Right.
then I will file another motion for prosecutorial misconduct and ask for a hearing on that, and subpoena witnesses in. The state will move to quash the witnesses that I will be calling in, and we'll have hearings going down that path. But this is something, no offense to this court, but I do not know how this court says that's the only thing that matters to me. There's a whole laundry list that deal with not only conflict.
That's what I'm asking. Do you have any case law that tells me I have to do that? I'm happy to do that. You cited Rutledge, and I read Rutledge. Rutledge doesn't
I
say
have
any
no
of those
case law in
things.
front of me right now that says you have to do that. But I would think it would be the inherent authority of this court that you should do that. And there's certainly nothing that says you can't do that.
That's usually that podium that talks to me about my inherent authority, which I don't exercise. I'm happy to do whatever a statute, case law,
Well, let's-
criminal procedure tells me to do. I don't make up things on my own.
Then I ask the court, let's go one step at a time. Right now, Mr. Demans now has been informed that Ms. Liberty is under investigation, and let us see what he decides. If he doesn't want us on the case anymore because of this, then all the things I've raised will be raised by another set of counsel. But if he does, we will be filing other motions in order so that we can get these questions answered, because Mr. Demans needs to know these before, quite candidly, he can make that choice. Now, he can say right now that he wants Miss Liberty, but after these facts come out, depending on what those facts are, he may decide he doesn't want Miss Liberty or the rest of the defense team. So we'll take it one step at a time.
So your request is you want me to hear any of these today? And
I don't think we can.
when would you like me to reset them?
I do not know how long it will take. Miss Liberty is not in town yet right now. She's on a plane. She got snowed in Montana yesterday. Drove from Montana to Seattle. She was on an airplane ready to come here, and they canceled the flight while she was on the tarmac. She got another flight including Phoenix. She's now on a plane from Phoenix to here. Almost all these motions that you went through are Miss Liberty's motions. So A, for logistical purposes, we can't hear those motions this morning at least. We're hoping that she's back at 1:30. But I do think it takes some time for us to talk to Mr. Demans. She certainly needs to talk to Mr. Demans. So, you want to reset it for, I don't know if we can speak to him tonight sufficiently or not. You want to put it on for possible motions tomorrow and status tomorrow? You can, but I'm not sure that's enough time to talk to him.
It's not enough time, well, you can't do it. And we need to know, if I may be heard.
Yes, sir.
We need to file, based upon your Honor's comments, we need to file a motion requesting certain things about this investigation. Concerning the taint team, whether or not they relayed any of that information to the prosecutors or the investigators in this case. And I want the court to know, they didn't tell us. Apple informed Miss Liberty that a search warrant was issued on her Apple account back on December 13th, 2023. As a result of that, I contacted the Broward Sheriff's Office. Enough time, well, you can't do it. And we need to know.
That's weird. Jump to
If
that.
I may be heard.
Just waiver of that, or she will no longer be his lawyer. And then he has to make the same decision for all of his other lawyers. And he is going to trial September the 10th, 2025. So we need to do this now. So how long will it take for you to get a copy of the affidavit and a copy of the search warrant and give it to opposing counsel?
I'll have to speak with my office, and if you can have a week to figure this out.
Judge, they've had since December of 23. They didn't even have the courtesy to inform us of a pending investigation. We had to learn this from Apple.
But you're telling me it relates to this case.
To the tampering case.
So why would this be different than any other search warrant in any other criminal case? defense counsel would be entitled to it?
Because she's not a subject that's been charged yet, potentially could be. It's pending investigation. All I can say is, again, pending investigation, there is a team in place, and it's still pending. So it's not like we have to hand over discovery to her. She's not a listed defendant yet.
No, but let me repeat myself. Mr. Demans has to make an informed decision about who he wants his lawyers to be. He's now been sitting in our jail for 2,100.
The state that all crazy trials are from, Beverly. It's Florida.
159 days. So how long would you like to be able to make that decision?
I can't determine when the investigation will be over. That's up to the Broward Sheriff's Office, but I can, as I said, I'm just asking for a week to determine whether or not we need to file any sort of motion to prevent the search warrant from being handed over.
I just can't imagine any legal grounds that would not happen in this particular case. It's a death penalty.
I understand
It's a
that.
death penalty.
And then I'm asking for at least a day or two. At
You
minimum.
decide by tomorrow. I've also reserved all of tomorrow. I took over Division FT. Judge Murphy had 44 pending first-degree murder cases. I've set them all for trial. I'm booked to trial through July of 2026. So if you all think I have 2 entire days at some point in the next 18 months to do these again, I do not. So
Understood.
I'm not sure what it is you want me to do. You don't want me to do anything else today.
We can't. We can't under the Florida rules.
So do you want me to leave them on for tomorrow? You will have the balance of today to discuss all these issues with Mr. Demans, and state you will have the balance of today to discuss some reason why you can't just turn over this affidavit and search warrant?
That's
I
fine.
mean, it may be something innocuous. By the way, for the record, I don't know anything about this. No one brought me a search warrant, so, but maybe it's something so de minimis that Mr. Demans is going to say, that's fine. If there's any conflict, I'll waive it, and, let's get to work. Or if not, I guess he's going to have to go find 5 other lawyers to do this who are going to be ready to try a capital case in 9 months. So how about tomorrow at 9:30?
We'll be here.
State tomorrow at 9:30?
That's fine, Judge.
And it can't, again, Ms. Buckle, I'm not picking on you, but the answer can't be, my office told me X, Y, Z. Someone better be standing here with some authority that tells me they can't do it. Okay?
Judge, one other thing.
Yes, sir.
You mentioned about the trial schedule, and we're obviously going to try to do it. I just want to let you know, the matters that were appealed are still up in front of the 4th DCA. The state, I believe, just filed the last document in the case, or there may be one more that they need to file, one more reply brief. I would suspect that it's going to be set down for oral argument, and then I don't know when we would get a ruling. The problem is the stay that was issued by your previous judge. We cannot go into anything on any type of discovery as far as depositions, as far as motions, as far as anything dealing with the matters that are up on appeal. So when that all comes back, we will be rushed to get everything else done. Just want to let the court know, we're under the mercy of the 4th.
Is there anything pending at the 4th DCA regarding the tampering?
Yes, everything that was on the homicide is also on appeal for the tampering because it's the same evidence.
Yep.
And Judge Murphy entered an order.
Entered an order that says you can't do depositions?
We can do depositions on things that aren't on appeal. So we have been doing depositions on things that aren't on appeal.
For example, you did not read, unless I missed it, but there's a motion in which I'm asking the court to make the state tell us what of the 2 million or whatever amount of Instagram messages they intend to use at trial. That was filed a long time ago. We can't have that hearing because the Instagram messages, the whole thing is up on appeal. So we can't even go into that motion. Those are some of the things that await you.
Well, couldn't I give you rulings on all those, depending on what, if I rule some messages are in and some messages are out, your example, and the 4th DCA says they're all out, then they're all out.
Judge, I wanted to move this case. I'm just...
Do you have any objection to doing that?
We're not the ones that filed this day.
Do you all have an objection to doing that?
Well, I think I'm confused on the motion that you're bringing up because all of the Instagram, if I remember correctly, I have to look, is up on appeal.
Right.
So, I mean, it would kind of a waste of time to do the motion.
Oh, no, a waste of time is reserving 2 entire court days and doing nothing. That's a waste of time. So do you have any objection to going forward and me hearing and ruling on any and everything that's pending?
I think that we should start with the things that don't affect the appeal, and then, because there's plenty of those to be heard, and then we can go forward potentially with the other ones.
And I'll be candid, I did not think we were hearing the Instagram matter whatsoever. So I have not looked at that motion.
Okay, so why don't we do it this way, all right? He's going to remain on the docket tomorrow. I have a few other matters on both FX and FT, so let's call it 9:30 tomorrow. And defense, you can come in and tell me if you had a chance to talk to your client, because if he's going to waive any potential conflict, then I guess it doesn't matter.
Yes, it does, Your Honor, because he'd be waiving a conflict without knowing what's in the search warrant affidavit.
Correct.
So therefore it would be an invalid waiver because he's not totally informed of the facts.
Okay, you're going to tell me what you want to do, state, maybe you can identify the motions that you think we can go forward. I mean,
We sort of addressed it in the motion to strike the notice, because we've been asking since our hearing in October to know what motions are going forward the next 2 days. Couldn't get an answer. We've asked in depositions from Ms. Liberty, couldn't get an answer. We emailed, we couldn't get an answer. And then just a few days ago, we got a notice of hearing. Half those motions aren't even filed within the court file in Odyssey. So we identified, I think, 4 that we are ready to go on, that we filed responses on. There's no motion filed for some of these
you're going to go to
titles.
trial in September. I'm not prejudging things.
I hope so, Judge.
No, I can absolutely guarantee you, he's going to go to trial in September. So I'm going to do everything that I can. If I have to rule on things during trial, which is an awful way to do things, because I know you both know, but if that's what it comes to, then that's what we're going to do. So,
Assuming we're still on the case. And that's a big assumption at this moment.
And just, we're still asking for proper notice of what we're actually
I
going to
did,
hear.
well, I'll take the blame for that. All pending motions. That's why I put that down to the law. All pending motions. They're asking for I believe, they're asking for a Daubert hearing on cell phone records. They're asking for a Daubert hearing on some other matter, cell phone mapping. There's a whole bunch of things that they
Some of those have already been ruled on, Your Honor. The ones that they've noticed, I think, and again, Ms. Liberty admitted to this the last time we were here in front of Your Honor, that she filed things with the wrong case number, wrong title, and she's going to fix that. None of it has been fixed. So the state is entitled to proper notice so that we can respond accordingly.
We'll see you tomorrow morning. Fair enough?
Okay, I'll see you at 9:30 tomorrow. Ms. Wilcox, does that otherwise conclude FX and FT for today? Okay, so the FX and FT are both going to otherwise be.
All right, so that was yesterday. They did have court this morning, and the judge ended up giving him a deadline of having to answer if he's getting new counsel or not on February 18th of this year. But a couple things with this. How crazy is it to have your defense team and hear the rumors, not directly from the state prosecutors, that one of the attorneys was going to be coming under investigation for this, being barred from being able to see their client for a year and a half without anything formally given to them. And then it took this hearing for the judge to then say, yes, she is in fact under investigation. Not even the state prosecutors did that. So that is wild. So yeah, now they have until February 18th. He had to have waived his right for a speedy trial, because if he's been in jail for 2,159 days and then they're saying that his trial date is going to be in the summer, July 2026, that's such a long time away, having had that much time in jail as it is. So I'm assuming he waived that. It will be interesting to see if he goes with new counsel. And one thing that I didn't see, but I read about, so maybe I just missed it while I was dealing with computer stuff, but when he walked into the courtroom, he actually fist bumped his attorney that was there. So he is pretty tight with these attorneys. He's had them for quite some time. And I think getting rid of them is going to be very hard to do since he has already built that trust and relationship with them. But if one of the attorneys is going down and actually is found, tampering with evidence or whatever it's going to be, that is almost like assured a guilty verdict for him. It's not going to be good at all. So hopefully he's actually weighing all his options in and taking the best route for himself. And it will be interesting to see what happens with this attorney. We'll have to be following it. Very rarely do we get cases like this that happen where an attorney may have gone too far and stepped in to this criminal action and is now getting dragged down. But if that's what she did, then she deserves it, and we will be here to watch it and see how it unfolds. So this was a good live. I am not doing another one today. I did one earlier if you missed it and want to catch back. I will be back on tomorrow, and I have a couple more lives, and I'm also putting out Ruby Frank, her daughter, wrote a book, and I talked about it briefly in another live, but we're going to get into that. I actually ordered the book, but I have a few different passages from it that I want to go over with you guys because I think it's interesting, and also I think it could be helpful for other families or people in similar situations. And I think the book itself would be a good promotion for people who may actually need the help and can relate to somebody who's been through the types of issues that she has gone through and her whole family has gone through. So we will be on more of that for tomorrow, and I will see you then.